webinar on navigating leave of absence laws in California. This is presented by Heffernan Consulting, and we are so happy that you can join us. My name is Phaedra Buxman, and I'll be your moderator today and also be monitoring any questions you may have during the session. Before we open up the session, let's go ahead and just cover a few key items. All of the materials today for resources can be found at the website where you may have registered. You should be able to see that website on your screen. It's www.aspenrmg.com/HeffernanWebinars.htm. And so if you scroll down the screen, what you will see is the title of the webinar, Navigating Leave of Absence Laws in California, and there's a PDF of the presentation, as well as some great resource materials that our presenter, Anne-Marie, has provided for you. With that in mind, you can also register for future webinars, and those are listed here on this same web page. We do have a webinar tomorrow, the 10 winning tactics for selecting A&E firm business insurance. Next week, presented by Anne-Marie also, is successful separations, and in April there is Obama's DOL proposed fiduciary rule and what it means for your retirement plan. So this could be really good for your retirement services information. We also provide the mandatory preventing sexual harassment presentations. We have 3 English presentations this year and 1 Spanish. The next one is June, and then September for English and October for Spanish. You can register and pay for those on this page. So it's just that top link there on the registration page. All right, so now we know what's upcoming and where you can go for preventing sexual harassment webinars. I'd like to let you know that if you have any trouble with your internet connection during the webinar, we do recommend that you leave the presentation and log back in. If you have audio difficulties or a telephone line goes dead during the call, please hang up and call in to the same number. If all of the lines go dead, watch the on-screen chat box for an alternative call-in number. We'd like you to feel free to ask questions and provide feedback during the presentation by using your chat or text box. If you're using a tablet, you may have to tap on your screen to get an options bar to come up, and then you would select the appropriate option. We may not be able to immediately respond. However, we will try to work your questions and feedback into the presentation. If we can't get to your question or comment during the session, we'll stay online for a few minutes afterwards, or we will respond by email. You can also email us. Our email address is down at the bottom of that resource screen. It's moderator@aspenrmg.com for up to 24 hours after the webinar. Today's webinar will be a 1-hour presentation. Again, questions and comments are encouraged throughout. With that, I'm going to turn the screen over to our presenter, Anne-Marie Toll-Mason, and she's going to share her presentation with us. So one moment while I make that happen. And as Anne-Marie loads her screen, I'd like to give you a little information about Anne-Marie Toll-Mason, who is facilitating the webinar on behalf of Heffernan Consulting. She is also the president of HR Source Consulting and a managing consultant with Aspen Risk Management Group. Anne-Marie is an HR professional with 20 years of practical management and corporate training experience. She's an instructor and facilitator for various HR management topics, including preventing sexual harassment to hundreds of companies. She holds the designation of Senior Professional in Human Resources, is the former president of the Society of Human Resource Management, the San Diego chapter, an expert witness for legal proceedings related to harassment and discrimination, and also an investigator for harassment and discrimination complaints. So Anne-Marie, we are so glad to have you, and I will turn the audience over to you.
Wonderful. Well, thank you very much for that introduction, Phaedra, and welcome to all of you. I'm really pleased to be here today to talk about such an important topic. And I think that this is something that touches all of our organizations at some time or another. And I hope that this information will be useful to you, if not now, at least sometime in the future. And as Phaedra mentioned, this is an interactive webinar, and we do encourage your questions and comments throughout the webinar. And you can do that by using your text box or chat box, depending on what type of, if you're using a tablet or a PC or a laptop, you should be able to find a place somewhere there on your screen where you can type in questions and comments. And although we may not get to your question or comment right away, we do intend to address it before the end of the webinar. So we will stay on the line at the end of the webinar until we have addressed your questions. Now, please note that if you have very specific questions regarding a situation in your organization, we may not be able to answer that to the fullest extent. It's often difficult to get all of the details. So I would encourage you to seek out some other legal advice because sometimes these things can get very convoluted. But we'll do our best to answer your questions, and with that, let's get started. I want to just point out, as I mentioned, that the information today is not intended to be legal advice. I am not an attorney. I'm simply an HR professional, although I've been practicing for a long time, and I've seen many different types of leave situations arise, and I do try to stay on top of the latest laws. I definitely am not one to give legal advice. So if you have any significant employment decisions, please do seek legal counsel first. And when you see this question mark, that means that we're going to launch a polling question, and that question is going to show up on your screen and it's going to give you multiple choice answers. So there's going to be a question, and then you all are going to be asked to provide your answer, and then we'll talk about it after. So Phaedra, will you launch our first question and get everybody started?
Absolutely. Let me go ahead. All right, everyone. So on your screen, what you will see is the question, do you have any employees out on a leave of absence at the present time? So you can click on yes, no, or not sure. As this is our very first polling question of today's webinar, I give you a little extra time, but generally these polling questions are on the screen for about 30 to 45 seconds, which doesn't seem like much, but the more questions we have, the quicker you all become at clicking your answer. Once we have reached a good amount of input from our audience, I will go ahead and close it down and share the results with all of you. So you have about another 5 or 6 seconds. If you're in a group setting, if you'll just take a consensus for your group and click on the one that the most people agree to. All right, I'm going to go ahead and close this down, and then I'm going to share that result with you. So Anne-Marie, 61% of our audience said yes, they do have somebody out on a leave of absence. 38% do not, and 1% is unsure. So I'm going to go ahead and close that down and turn the screen back to you.
Okay. Well, I'm always interested to see what our audience is made up of, and it certainly makes sense that you would tune into a webinar when you've had to deal with this particular topic. And kudos to those of you also who haven't yet had to deal with a leave of absence, or maybe not, at least presently, and are tuning in for the information. So for those of you who have experience with leaves of absence and you have some best practices to share with us, please feel free to do that throughout our webinar as well. Our objectives today are many. We are going to explore all different types of leaves. We are going to look at both federal and state leaves, and today's webinar is specifically related to California, and because that's where my expertise lies, and I believe that California is probably one of the more complicated states, at least of the ones I've worked in, of all as it relates to this particular topic. We'll also talk about the California's pregnancy disability leave and a federal leave which is called the Americans with Disabilities Act. And then you also, of course, know that in some cases our employees go out on workers' compensation leave. So we'll talk about how some of these leaves interact. And there are other leaves as well. We're not going to delve in too deeply on each and every leave. I'm going to hit the major ones and then point out some of the others. It's complicated because many of our leave laws do overlap, and the California Family Rights Act and the Federal Medical Leave Act have a lot of similarities. The other thing is, of course, regulations change very frequently, and we have to stay up to date. The thing that we need to think about is, what are these leaves and what do they provide for our employees? Because we have to adhere to both state and federal laws and comply with the law that is most friendly or most beneficial to our employees. One of the very first questions we get, or I get as an HR consultant now, is a leave paid or unpaid? This is the first question asked by both employers and employees. So the bottom line is there's generally no legal requirement for a company to pay their employees who are out on leave, except for if they're out for an organ and bone marrow leave. Employees on a workers' comp leave, of course, receive a portion of their salary, but that is through workers' compensation insurance. So there are some insurances that can come into play, but there's no legal requirement except for that one leave mentioned here that the company has to pay employees. Now, you will want, and I'm going to refer to this frequently during our time together during this webinar, that you'll always want to fully understand what you are promising to do for your employees in your handbook and what you've done for your employees in the past. So past practice, past precedents, and what's in your employee handbook should also be considered. A lot of times companies do things that are not necessarily legally required, but they do something above and beyond. So let's talk about organ and bone marrow donor leave. That applies to companies that have 15 or more employees who have been employed for 90 days immediately preceding their request for the leave or their commencement of that leave. Up to 30 days of paid leave in any one-year period for a person who's donating an organ, and up to 5 days leave in any 1 year for employees serving as a bone marrow donor. In addition to this leave, an employer shall maintain and pay for coverage under a group health plan during the employee's full leave. This is a fairly new law. So if you haven't had your handbook updated in a while, this might not be in there, which in and of itself is okay if it's not. It doesn't have to be in a handbook, but certainly you do have to comply with this law. So again, the question, paid or unpaid? Well, there's insurance, and in California we have state disability insurance and paid family leave insurance, and both of these can come into play when an employee is out on a leave of absence. And it is up to us as the employer to tell our employees what their rights are and what their eligibility rights are for these particular insurance plans. So the state disability insurance provides for up to 52 weeks of disability insurance. The paid family leave insurance is funded, also provides up to 6 weeks of insurance if people are out on paid family leave, if they're out on family leave. Both of these are funded completely at the present time, at least, by employee contributions. So you'll see that line item as a deduction on your paycheck. It is administered by the EDD, the California Employee Development Department. You need to consider what your company has in place for salary continuation. Some companies do offer to pay for all or part of an employee's leave. So you'll want to see whether or not you have a policy about salary continuation. Also, your company probably offers some sort of paid time off, maybe vacation and or sick leave. And then a lot of companies will offer a short-term disability insurance or or a long-term disability insurance plan. So you'll want to review all of these as it relates to your particular organization to see if you have something that can benefit your employee when they're out on a leave of absence. So the two major leaves that offer protections for employees are the federal leave and the California leaves. This is FMLA and CFRA, Family Medical Leave Act and the California Family Rights Act. So we'll be talking a lot about those today. So eligibility for these two acts are very similar. The employee has to be employed for a year, and for 12 months in the preceding 7 years, and then have worked at least 1,250 hours during the 12 months preceding the date the leave would commence. Now, it's important that you have designated what the 12-month period is in your policy. For example, you can have a rolling 12-month period that is measured backward or forward from the date the employee uses any leave. And then you might note, too, that for these leaves, part-time employees are also eligible on a proportionate basis. Remember, they only need have worked 1,250 hours during the 12 months preceding the date the leave would have started. And they have to be employed at a work site where the company employs at least 50 people within a 75-mile radius of that particular work site. So if you're an organization that doesn't employ at least 50 employees within a 75-mile radius, then these laws wouldn't apply to you. And you'll want to review your handbook to make sure that it's not in there. Sometimes companies will inadvertently put these leaves in their handbooks, not realizing that they don't apply to them. So if you do have this leave incorporated into your handbook, make sure that you have these eligibility requirements included in there so that employees know that if you fall below these 50 employees within a 75-mile radius, that these leaves would not apply to them. And we have another question.
And of course, I had myself muted, which is useful. All right, so here is our polling question. Do you have 50 or more employees in a 75-mile radius? So your possible answers are yes, no, and not sure. And we actually have two questions, Anne-Marie, that if you are comfortable, maybe we could answer those after we wrap up this polling question.
That sounds like a great idea.
Great. So we'll go ahead and let everybody provide their input here, and then we'll answer these two audience questions. And look at how fast you all are. We're 33 seconds in, and almost all of you have added your vote to this. Great job. Okay, I'm going to go ahead and close the poll down and share the information, and then we can ask those two audience questions. All right, Anne-Marie, 70% of our attendees say yes, they do have employees, more than 50 employees in a 75-mile radius. 30% do not. So our first question is, doesn't the PFL only apply to certain size companies?
Paid family leave?
Yes.
Paid family leave applies to anyone.
Perfect.
But that's insurance.
And, right. It's different than a law.
It's right. It does not provide for any leave. It just provides for insurance. So if someone's eligible for that insurance, then it's determined by the EDD.
Okay. And then the 75-mile radius, does that apply to schools or not?
I don't understand the question.
Let's see. So our attendee thinks that if you have 50 or more employees in that 75-mile radius, that it doesn't apply to schools.
Yeah, I don't understand the. I'm trying to think what that means. Maybe the person who asked the question can clarify that.
Okay, perfect. We'll let them type in additional information and maybe go back to that. And our last question that we'll take right now is, if you almost have 50 employees and have on-call student employees, does that still apply for that 75-mile radius?
Yes, it may. So if I were that company and they're so close, I would dig in a little deeper as to what the exact rules are regarding determining the 50 employee mark. Because I know that it goes back. I know that it goes backwards, and I don't know how far. So that's a very good thing to, if you're on the verge. Like maybe you're not right now, but maybe if you were last week, you might still have to provide the leave. So there's a lot of information on the web, and I would Google it, or I would call legal counsel and check with them.
Thank you, Anne Marie.
Yes, absolutely. Great questions. All right, so more about the Federal Family Medical Leave Act. This provides for 12 work weeks of leave in a 12-month period. And remember, we just talked about the need for every company in their policy to designate exactly what that 12-month period is. Otherwise, it is whatever is most advantageous to the employee. And you can tell that this can come into play if someone were to need a leave back to back, let's say. I need a leave, and then 6 months later I need another leave. Well, when does that 12-month period begin and end? Is it a calendar year? If I haven't designated and the calendar year is more advantageous to me, then I'll be able to take that leave again in 6 months, potentially. So this applies to the birth of a child and to care for a newborn child, the placement with the employee of a child for adoption, and so forth, to care for the employee's spouse, child, or parent who has a serious health condition, and a serious health condition that makes the employee unable to perform the essential functions of their job, and then any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member. And then we also have military caregiver leave. 26 weeks of leave during a 12-month period to care for a covered service member with a serious injury or illness who is the son, spouse, daughter, parent, or next of kin to the employee. Now, the California Family Rights Act provides something that's a little bit different. It provides for the birth of a child for the purposes of bonding. All right? So this leave provides bonding leave, which the federal leave does not. So the state leave provides leave for bonding. Federal does not. Otherwise, you can see there's the rest of it's similar. Both of these leaves, there's a notice required by both the employee and the employer, of course. The FMLA and the CFRA run concurrently when it's to care for a family member with a serious health condition and when it's for the employee's own serious health condition. So then these leaves will run at the same time. They both provide for intermittent or reduced hours, which is something that can be very difficult to track. And if you have a number of employees, it can get very, very time-consuming to try to track all this. And I know that there is some software available that provides a lot of tracking as well as form, that provides organizations with forms and keeps everything up to date. So if you deal with a lot of leaves, I would strongly suggest looking into this software and maybe automating this process, because dropping the ball on leaves of absence can lead to a lot of very serious compliance issues that rack up a lot of dollars for employers. Also, these particular laws allow for reinstatement, so a person is not, can't lose their job while they're out on these types of leaves. So if you're making decisions on, terminations or layoffs or things like that, if you have people that are out on leave, you definitely want to talk to a legal professional before terminating these people who are on leave. And then you have to continue any insurance benefits that the employee is currently enrolled in. And the important thing is you can require the employee to continue to pay their own contribution to the premium. So if I'm paying $500 a month right now out of my paycheck to cover my cost, my contribution to the premium, and the company's also, let's say they're putting in half, they're putting in $500. The company's still going to have to continue to put in their portion, but I am too. And if I'm not getting a paycheck, that means I'm going to, if I'm out on a leave, I'm going to have to write a check to the company. So all of that should be included in your policy and also in the notice that you're going to provide to your employee once their leave has been approved. Let's take a look at the big differences between FMLA and CFRA. Pregnancy is a serious health condition under FMLA, but not under CFRA, but it is under the pregnancy disability leave, which is a California requirement. CFRA covers baby bonding. We talked about that, and the FMLA doesn't. Domestic partners are not covered under FMLA, but they are under CFRA. And the FMLA has the qualifying exigency leave, and the CFRA doesn't. Also, the FMLA has leave for the care of the injured or ill service member, and there's a website there that you can go to get additional information on that, should that apply to you. All right. Pregnancy. Let's take a look at California's pregnancy disability leave. Now, this leave comes under the Fair Employment and Housing Act, and this is enforced by the California Department of Fair Employment and Housing. So that's the agency that oversees this particular act, and the California pregnancy disability leave comes under that act. So if you are disabled by pregnancy, childbirth, or a related medical condition, you are eligible to take this leave. And it covers employers that have 5 or more employees. And you can, if you're a nonprofit religious association, you will not have to cover your employees under this particular leave. All employees are eligible on the first day of employment if you're an employer with 5 or more employees. And a person can get up to 4 months of leave. Now, the regulations calculate the 4 months in hours instead of days. So the 4 months is defined as 1/3 of a year. And a full-time employee working 40 hours is entitled to 693 hours of leave. And then if it's part-time, you'd have to consider how many hours the part-time person works and then figure out how much leave they get. An employee who works 48 hours per week is entitled to more leave than someone who works 40 hours a week. So it says 4 months, but remember, you do have to do this calculation to make sure you're giving someone the proper amount of leave. And one of the things that I see more often as it relates to pregnancy leave is the misunderstanding that a person is entitled to 4 months of leave. It's only for the duration of the disability. So if I'm not disabled for 4 months, I don't get 4 months of disability leave. Disability leave is just that. It is time off for the period of time when I cannot work because of the disability. It could be 6 weeks, 8 weeks, it could be the full 4 months. It's important to note that the pregnancy disability leave runs at the same time as FMLA. So if I'm eligible for FMLA, then I'm eligible for California pregnancy disability. Those are going to run at the same time. And then I can also take up to 12 additional weeks after my disability leave is all over for baby bonding. And that's under the California Family Rights Act. This leave also allows a person to transfer to a less strenuous or maybe a less hazardous position if it is medically advisable. So one thing to note here is that you can certainly discuss these things with your employee who's pregnant and ask them if there's any particular accommodation that they might need. And you would want to get a medical note. And also, you wouldn't want to force the employee if they're not requesting it, if their doctor isn't requesting it. Don't force them. So, for instance, I had a client who was thinking that he was being very considerate to an employee who was pregnant, and he had taken her off of the travel schedule. She was a salesperson who normally traveled for her job. And he had taken her off the travel schedule, thinking that it would be easier for her if she didn't have to because she was pregnant. And she turned around and sued him for pregnancy discrimination because she was being treated differently than everyone else. So in this particular case, no good deed goes unpunished, but I can kind of see both sides of the coin here. He's trying to do a good thing, and she's pointing out, well, hey, when doing this, my opportunity for sales commissions was diminished. So, you want to make sure that you're not automatically doing these transfers or providing these accommodations if they're not wanted. A person could receive reasonable accommodation related to the pregnancy, the childbirth, or any related medical conditions, again, at the advice of a health care provider. Also, of course, a pregnant person cannot be fired. They can return to their job. And the leave is prorated for part-time employees. And there is, with this leave now, a insurance continuation requirement, just like we talked about before, that exists with the FMLA and the CFRA, that you can require the employee to continue to pay any contributions that they would normally have paid if they were getting a paycheck. So let's look here at an example. Susie has worked for the company for 5 years. She's pregnant and has morning sickness all day, not just in the morning. She also has many doctor's appointments that she takes for, of course, prenatal care. Is she entitled to take that time off? And I'm going to ask our audience to use their chat box or their text box, and you can just type in a yes or no answer.
All right, we are getting some responses now, and we are mostly getting yeses.
All right, yes indeed. If Susie is eligible for a pregnancy disability leave, the time she takes off for medical reasons related to the pregnancy can be counted against her total hours of California paid, pregnancy disability leave. So make sure you're tracking that. All right, here in this particular situation, Susie ended up taking 4 months off during her difficult pregnancy. Now she wants another 3 months to stay at home and bond with her baby. Is she entitled to do so, and do you have to continue her health benefits? Again, I'm going to ask our audience to please put your answers in the chat or text box.
A little more variety on this one, but mostly yeses.
All right. Yes and yes. Under the California Family Rights Act, she is entitled to the time off and to continue her insurance, and also under paid family leave. I always find it helpful to look at specific examples. And these examples are going to show pregnancies and the different total amount of time that a person may be entitled to. In this particular example, this person was entitled or eligible for a total of 20 weeks of protected leave. So let's take a look at how this worked out. At the very top of this slide here, you can see we have the different leave laws. We have FMLA and PDL running concurrently for 8 weeks. So this is the period of time that the doctor has said that this woman cannot work. She's disabled. All right, that's what this is representing. So you can see that during the period of time that she is disabled, she's unable to do her job, doctor says you can't work, she is collecting or eligible to collect short-term or the state disability insurance plan through the state of California. So that's for 8 weeks. Beginning at the end of the 8 weeks, FMLA is still continuing because remember, FMLA lasts for 12 weeks, right? So FMLA is continuing, and the California Family Rights Act has begun. We've begun the countdown for the California Family Rights Act. The California Family Rights Act runs for 12 weeks, right? There's an additional 4 weeks left of FMLA. So we have FMLA, CFRA running concurrently for 4 weeks, and then we have the remaining 8 weeks of California Family Rights Act. And all of this time is these 12 weeks are that baby bonding time that we talked about. During this period of time in California, the person would be eligible for paid family leave. All right, so paid family leave insurance would come into play for 6 weeks of that 12 weeks of bonding time. Shall we look at another example? All right. Example 2. In this particular example, this person has let's see, the employee's health care determines the actual amount of time. So in this particular case, the doctor has said that this person can't work for 17 weeks. It must be a more difficult pregnancy than in example 1. So in this particular case, pregnancy disability leave is running for 17 weeks. FMLA only runs for 12 weeks. So for 12 weeks, they're running concurrently. Then pregnancy disability leave ends, right? And you can see that during this whole time at the bottom of this graph, SDI, state disability insurance, is paying this employee. Now, these insurances don't pay employees their full salary, but it is at least a portion of their salary, although it's a small portion. But you should definitely encourage your employees to apply for these insurance benefits. So we have SDI for 17 weeks. The person's disabled 17 weeks. And then the CFRA kicks in for the after the birth of the child for the baby bonding time. And again, the paid family leave insurance administered by the EDD is running for 6 weeks. So the SDI ends, paid family leave insurance begins for 6 weeks. So then this person will have insurance for 17 plus 6 weeks. So for 23 weeks, this person will be receiving some kind of insurance payment. And then all of those benefits have been depleted, and then, but they still have time off left. Now the person doesn't have to take all of that time off, The person can elect to come back sooner. They're not disabled by their doctor. The doctor has given them permission to come back to work, but they're taking advantage of their entitlement to this baby bonding leave. Now, some women will save some of the leave to use later in the event that their child becomes sick, or perhaps their daycare provider goes out of business or something like that. So this is another example, and you can see that the amount of time that the person is entitled to take is longer than the previous example. This particular example is showing that the employee has used all of their pregnancy disability leave and all of their family medical leave before the child is even born. So in this particular case, they have used up all of their entitlement under both FMLA and PDL. So you can see the concurrent leaves running here from left to right, FMLA and PDL at the top. And then PDL ends at the end of 17 weeks. The baby's not born until the 20th week, all right? But all that time the person is disabled, they are eligible to collect short-term disability, state disability insurance. So there is technically a period of time here between the 17th week and the 20th week where the person is not covered under any particular leave law. Now, does that mean that in this period of time in between that you would want to consider terminating that employee? You can see where that probably wouldn't play out well. Although there are really no reinstatement rights at that particular point in time, it would be probably a very hard case to make to let someone go who was disabled, because you have the Americans with Disabilities Act that's protecting a person during this period of time when they're disabled. Then we have after the child is born, of course now we have the California Family Rights Act for baby bonding. That's going to run for another 12 weeks. So in this particular example, this employee can be out for 32 weeks. And a lot of employers, a lot of our organizations now really depend on remote employees. So how does this affect our remote employees? Well, the Department of Fair Employment and Housing counts all of the employees that the company has when determining eligibility for pregnancy disability leave. For example, if your company has one employee in California that is pregnant, 2 employees in Maine, and 3 in Texas, the 1 employee in California is eligible because the employer has a total of 5 employees. So this particular law does not require your employees to be in a 75-mile radius. Under the provisions of the Family Medical Leave Act, an employee's personal residence is not a work site in the case of employees such as salespeople who travel a territory and generally leave to work and return from work to their personal residence, or employees who work at home as under the concept of telecommuting. Rather, their work site is the office to which they report and from which assignments are made. So that's important to note to see whether or not there's eligibility for FMLA. For example, here we have an organization that has 50 employees in Boston and 1 longtime employee who works from her home in San Diego. The employee in San Diego is eligible for leave under the FMLA. All right, now let's talk about workers' comp. Workers' comp insurance. That's, of course, an injury or illness that occurs while the employee is performing services under the scope of employment. The injury is caused by employment. And now we have a question again.
Okay, let me go ahead and launch that polling question for you. Do FMLA and CFRA run concurrently with workers' compensation leave? So you can click yes, no, or not sure. This one can be a little trickier than some of the other questions. Look how quick everybody is on their clicker. We're 25 seconds in, and about 75% of you have provided your input. Thank you so much.
All right. So what are people saying generally?
Let me go ahead and it is right now we are at 44% yes. So I'll go ahead and close down the poll and share the audience answer. So 44% yes, 29% no, and 27% are unsure.
Okay. Well, you know, that's pretty much what we get when we run these webinars on this particular topic, because it is so confusing. And so what is the answer? The answer is yes. FMLA and CFRA do run concurrently with workers' compensation leave. And the thing is that you have to notify your employee that you are running that leave at the same time, and advise your employees of their, you know, of the fact that you're doing that and what their entitlements are. The leaves for work-related disabilities have no threshold service requirements, no size limits, and may go on almost indefinitely. Reinstatement is required unless you can prove the employee is unable to return, or there's a real defensible business necessity. And employers must also comply with reasonable accommodations and enter into the interactive process requirements of the Fair Employment and Housing Act. And it runs concurrently with FMLA and CFRA, and you must designate and notify the employee. You can, of course, require your employees to continue to pay their insurance contribution for a maximum for the duration of the FMLA, and then you can offer them COBRA. So a lot of times I have companies that have had employees out on workers' comp leave for years, and they're still paying the complete cost of the employee's insurance. I'm not even requiring the employee to pay their portion. But if you have your policy set up appropriately and you're giving the right notice to your employee, then you can eventually end at the end of the FMLA and CFRA period, you could end their insurance and offer them COBRA. So I wouldn't suggest doing this if you have employees who've been out on years and all of a sudden stop their insurance, but maybe to look at, this is something to look at moving forward and something to add into your policies. Also, we have the Americans with Disabilities Act, which requires an employer to provide a reasonable accommodation to anyone, including a job applicant, who has a disability, unless doing so would cause the employer significant difficulty or expense. A reasonable accommodation can be any change in the work environment or in the way things are usually done to help a person with a disability apply for a job, perform the duties of the job, or enjoy benefits and privileges of employment. So what does this mean? It means things like alternative schedules, weekends off, you know, working half days, maybe working from home, you know, any number of things. Americans with Disabilities Act, again, reasonable accommodation might include accessibility with a wheelchair, a reader for somebody who's blind or hearing impaired. If employees are still disabled when the FMLA and the CFRA and the pregnancy, disability, or workers' comp ends, then consider the Americans with Disabilities Act provisions. So always think twice before letting a person go when these leaves end, because the Americans with Disabilities Act will still likely apply. Some other legally mandated leaves include the ones that are listed here, and some of them apply to all California employees, and some apply to those employers with 25 or more employees. And then also some with 15 or more employees. So it's important when your people ask for time off that you carefully consider any laws that may come into play and make sure that you're notifying your employees of those entitlements and complying with the regulations. Also, it's very important to note that FMLA and CFRA allow you, as the employer, to dock the employee's accrued vacation while on leave, but you can't do so if the person's out on workers' comp or pregnancy disability leave. And state disability and paid family leave insurance allows the employee to collect benefits for certain leaves, but they do not require the employer to provide leave if it was not otherwise available. And don't forget your own leave policies. You should check to see what you have offered in the past as a past precedent, and also look in your handbook and see what your handbook says. It might be time to update it. And here we have our last question.
Fantastic. I will launch that last question for us here. Okay, everybody, have you recently reviewed or updated your company policies, the employee handbook, as they relate to mandated leaves of absence? Yes, no, or not sure? Right now, we are running a little quicker on yes. We'll give everybody about another 10 seconds to provide their information. All right, I'm going to go ahead and close that down and share the results. So Anne-Marie, 55% of our audience said yes, 31 said no, 15 said not sure.
Well, I'm glad to see so many of you have been keeping these policies up to date. And for those of you who haven't yet, this is just a friendly reminder that it would be a good idea to do so. So what is a practical application of what we've talked about today? When a person talks to you about needing some time off, determine which, if any, leaves might apply to them. Review and revise any policies and notices for compliance. Make sure that you have designated your 12-month period. Require that employees pay insurance contributions, and determine when COBRA will begin. Make sure that's all stated in your policies. Properly designate and track leaves. Provide all the required notices and documentation, and before termination, always consider ADA issues, as well as all the compliance under those various leaves. There are also lots of resources available on the internet. I've provided some of these here, and you can download this presentation, which will have all of, this slide on it, and these are available to you. And also, please seek advice from an attorney or an HR professional when dealing with these complex issues. Proactive advice is always better. Ask before making your decisions instead of after. It's always easier. And then document processes for all leave requests and accommodation requests. So have a process in place that you can easily follow that when someone requests a leave. So just as you would with any other business process, write down what the steps are and make sure that you're adhering to the steps. Make sure you have all the proper notices and documentation in place for these leaves. Again, resources available to you are a copy of today's presentation. We also have various brochures and notices and forms available on the website. If you have any further questions, don't hesitate to type them into your chat box. And also, it's always a good idea to speak to your human resource representative or your manager if you have questions. And I know we may have some remaining questions, and I want to thank all of you who've joined us today. I really appreciate your time. And if you have any questions and if you want to stay on the line, we'll stay on until we've answered your questions.
Great. Anne-Marie, give me just one moment so that I can post an answer here about where the slides can be downloaded to everybody so everybody can see that. Again, it's at www.aspenrmg.com/Heffernan-webinars.htm. I will also be sending out a thank you email today, which will have that link enclosed in it. We do have quite a few questions, so I will ask them. So Anne-Marie, question number 1. Any rules within that regard to employment of both parents and them both taking leave to care for a new birth child? Uh-oh.
Oh,
Anne-Marie?
I was muted. That is a very good question. I think that both parents would be eligible, but I would suggest that you do a little research on that just to be certain. And the thing is, it very rarely happens. Both parents will take time off, except what I see happen is that normally it's the period, the baby bonding period of time. And so in other words, when the woman is disabled, the man is not eligible for any leave because he's not disabled, right? If he has to care for her, and then he may be eligible for time off because the law, the FMLA and CFRA, allow you to take time off to care for someone who's seriously ill. So my understanding is if that were the case, then they could both be off at the same time. And then for baby bonding, we often see that the man now will want to take some time off after the baby's born to spend time with his wife and baby. And many organizations encourage this, and it's part of their culture as a family-oriented organization. So that might come into play at that time too, because a man is entitled to baby bonding time, as is a woman. But because employees are not paid during that time, except for that very nominal paid family leave insurance, it's often it's unlikely that both parents would be able to take that time off at least much time off at the same time. Usually a man will take a few days. So I've never seen it really become a problem, but it is a good question, and if it happens, before making any decisions, I would do a little research.
Okay, and if an employee is out on an approved FMLA leave, can the employee respond to emails or be called to answer job-related questions without violating FMLA terms?
Well, so long as the doctor is allowing it and you're paying the employee, so you wouldn't be able to count those hours that the person is performing work as part of their FMLA time. I would strongly discourage contacting the employee, but certainly sometimes it's absolutely necessary. I would be careful about doing that. But I understand the business necessity for sometimes having to reach out to someone who's out on a leave. But do make sure that you're compensating them if you're calling them. Especially, you have to consider if it's a salaried employee, you really start running into problems, right? Because salaried employees have to get paid a full salary. So, yeah, that's a tough one.
For employers, do you have to continue the health savings account contributions when an employee is on a protected leave?
HSA contributions. I would think so, but I don't know the answer to that specifically. I'm just guessing that the answer would be yes. From a logical point of view, that just because employees are not supposed to suffer any kind of adverse consequence as a result of them being out on a leave. So, but I don't know for sure. I would check that out.
Okay. If FMLA and CFRA run together, can the employee qualify for CFRA to care for their domestic partner?
Yes.
Perfect. Next question is, if an employee's PDL goes beyond 4 months, does the leave turn into ADA?
Well, it's not, ADA is not leave. ADA is protection from disability discrimination. So yes, ADA is always in place when a person is disabled. The Act applies to anyone who, well, potentially applies to anyone who is disabled.
Okay. Does baby bonding leave start at the day the baby is born or when the pregnancy disability ends, for example, 6 weeks after birth?
It is, those are both the same. When disability, oh, I see what you're saying. It's when the disability ends. It's when the disability ends.
And for if it was a father taking the leave versus a birth mother, could it potentially start when the baby is born?
So let's go back to to the question that was just asked. Can we repeat that question, because I don't think I gave
Absolutely.
the right answer. Yeah.
So does baby bonding leave start the day the baby is born or when the disability? Okay.
When the baby is born.
Okay. Perfect. And then if employees are given an allowance towards their benefits, which covers their high deductible health plan premiums, and that is deposited by the employer into the HSA, does the employer still have to cover those premiums while the employee is on leave?
I would think so, but again, I'm not entirely sure.
That's pretty specific. They might want to seek additional information on that one.
Yeah, I think so.
With running a nonprofit church, a preschool or child care center, do they have to honor CPDL?
It's my understanding that they would not.
Okay.
But double check it. Again, I'm not an attorney. I'm just giving my best answers as a human resources professional.
And occasionally, Anne-Marie, when you're discussing leaves and the legalities of them and whether or not you have to apply to them, sometimes you'll use the term a business necessity. Would you explain what that means?
Well, that's a very good question. I would want to have lots of documentation. It would have to be, let's say that your organization is closing or something like that. I mean, it really has to be a significant defensible business necessity. Sometimes companies will use that. Oh yeah, well, we had good business reason, and then they're called out. On it. They've let somebody go. They fired somebody, and the courts or the agency will say, that really isn't a good enough business necessity. So it has to be something that you really have, a lot of documentation behind it to be able to prove it. It has to be a pretty serious issue.
Okay, thank you. Regarding FMLA and CFRA, is it applicable to employees who haven't worked 1,250 hours within the year because they're on a workers' comp claim leave?
Right. Right.
So is FMLA and CFRA applicable to them even though they haven't worked those hours within that year because they've been on leave for work comp?
I believe that if they haven't worked the hours and they're on leave, that they wouldn't be eligible. Now, hopefully that when the employee first went out on their leave, the company designated that workers' comp leave as FMLA and CFRA, and they, they used that leave when they were originally eligible for it.
Okay.
Right? If the employee never got to use it when they were originally eligible for it, and it wasn't properly designated as such, then they might be eligible for it.
Okay. In regards to PDL, even for a normal pregnancy, women are generally allowed to take a disability starting 4 weeks prior to the due date and then 6 weeks after the baby is born?
No.
No, because it's a normal pregnancy means it's not a disability, right?
A normal pregnancy is usually a week or two before the due date and then 6 weeks after. Unless it's a C-section, then it's 8 weeks after. That's what I see most often, but every woman's different.
Okay. Regarding an example that's provided in the presentation, we show that an employee is out for 32 weeks total, and there's that 4-week period which they aren't covered under FMLA, PDL, or CFRA. Does that employee still qualify for health benefits through the company after the FMLA and PDL runs out?
I would continue it. It's just not worth. It's not worth it to discontinue it for that amount of time. I wouldn't think, because then they become eligible for it again 4 weeks later.
Okay.
So my advice would be to just continue it.
All right, and this may be very similar, but I will ask it just because it's here and it's been asked. Mm-hmm. How long do you need to continue medical benefits for an extended leave, 4 months of PDL plus 12 weeks? Do you maintain insurance throughout the leave?
Again, until all the leaves have been used, you have to continue. Once all the leaves have been used up, then you can put them out on COBRA.
Okay. And if you have an employee who has a permanently disabled special needs child and that employee can't work past 8 hours a day, is that covered through FMLA?
I don't think so.
I don't think so either.
Mm-mm.
And what type of documentation is good for notification for when the baby is born for the baby bonding leave?
Well, that's California Family Rights Act, so you want to provide all the information on the California Family Rights Act. And you can go to the website and look up the brochures and so forth that you need to give out. But there's a letter that you should give out when the employee originally goes out that's going to go over all of the conditions of their leave. You know, what happens to their vacation time? What happens to their sick time? Is it going to continue to accrue? Are they going to get paid holidays? Are they going to have to pay their portion of the insurance contribution while they're gone? Or are you going to save it all up and hit them when they come back with a big bill? All that stuff should be clearly communicated initially, along with, this is what you're eligible for. This is the insurance is you're entitled to apply for, so forth and so on. So you have to give out all that information, have that discussion with your employees.
Perfect. We are down to our final 2 questions, and I'm going to ask this one because it ties into what you just, part of what you covered. Regarding vacation accrual, and now this employee is on a work comp leave, so while they're out and being paid through work comp, should they still be accruing vacation or other paid times off?
It's my understanding that you wouldn't have to, but I am not a workers' compensation specialist, so I would double check that. I know that you don't have to allow that to accumulate when a person's out on an unpaid family medical leave, but if they are getting paid sick or PTO or something like that, then they should accrue like they would otherwise.
Great. And here is our final question, so bear with me. Our attendee was informed regarding CFRA, baby bonding begins when the mom's disability ends. However, the question is this. Please confirm that CFRA and PDL run concurrently and that 6 weeks of CFRA baby bonding time actually occurs when the mom is still on disability.
That's a long question.
I know. I think I think the clarification would need to be that baby bonding for the mother doesn't necessarily begin at the end of their disability time. So the disability, unless they've had surgical procedures or are medically disabled after birth, baby bonding begins after birth, correct?
Right.
Okay. And then, so I think the question then becomes CFRA and PDL running concurrently,
right,
with baby bonding at the end of the disability?
Yeah, I think that we're probably I'm gonna have to look at that question. I'm just having a hard time.
No, it's okay. I'll email this question to you,
okay,
and it is
perfect.
Our last question. I have two that I will email to you so that we can follow up on them. And Anne-Marie, thank you so much for for staying on with us. We really appreciate that.
I appreciate the questions. We had a great audience today.
Thank you, and I will get everybody all logged off, and I hope that you have a wonderful day.
Thank you, everyone. Have a great day.
Bye.